Hello. I'm Jessica Cook. I'm the attorney with Foundation Title and Escrow, and this is my husband, J.R. Cook. He is partner and owner at Page & Cook PC. So today we're going to talk to you guys about just some different things that agents can run into when it comes to potential litigation. Joey gave us several things we could touch on. I don't think we would have time to get through all of them, but we do have a few that I think are important to you guys. And one that I've seen a lot here lately, and that one is failing to disclose a property defect. That has happened probably at least 5 times in the last 6 weeks where an agent is calling me and the buyer got to the property, discovered a defect, and they walked, or they did end up getting to closing, working it out. But the ones that walked are now looking for an attorney to sue the sellers. So JR has some information on that one.
Yeah, so definitely ways to land yourself in court is going to be to fail to disclose a property defect. So as you all know, sellers are required to disclose the condition of a home, including any material defects. All right, that's a buzzword there. So what does material even mean in that regard? Well, generally speaking, material means any fact or condition that might affect a buyer's decision. I understand it's a very broad definition, and a lot can fit into that. But that is, generally speaking, what material means in regards to material defect. So what does defect mean? Another buzzword there. And the code has that identified. So a defect can really include anything: leaks, water damage, structural defects,
significant scratches in a floor that are hidden by a rug or furniture,
nuisances, crazy sounds or foul odors can be considered even a defect. So material defect, you must disclose it. And of course, you all know there's some exceptions to that. I think one of them is if you're a seller that's not lived in the property 3 years from closing. So there's a list of exceptions, but I won't get into any of those. And keep in mind, though, sellers are required to update those disclosures prior to closing, right?
Yeah, which is a form that you guys obviously have that you get signed.
And it's definitely a good idea to get that signed. That one missed signature could lead to a lawsuit. So it's great that you guys have that form in all of your transactions. Obviously, be strict on getting that signed and disclosed. Have you ever had a deal that someone's not updated properly?
Yeah, so a lot of times I get new agents in the office that they come to closing and they're just not thinking about having to get that property condition disclosure update signed at closing as part of their documents. So hopefully they go and get it signed after the fact, or usually the other agent will say something like, well, we can get this DocuSign or whatever. But I think that's something to stress to your newer agents for sure, the importance of getting those documents signed.
And unless it falls under one of the exemptions, it's not an optional form. The code, Tennessee code, literally requires it. It's the law. It's listed in 665205 if you want to look up the details of it. That is actually law in Tennessee. So how does a seller failing to disclose the defect of his or her property affect you all as agents, right? Because it's not your property. You're not living in it. You don't know how to disclose. You don't know everything about it. So how does it affect you all? Well, there's a number of ways. Even though it's not your property, you are the representative or an agent of the seller. And if the buyer and the seller end up in litigation because of a defect that was not disclosed, guess who's going to be named a co-defendant with that seller? The agent, the brokerage firm, potentially a home inspector, or somebody who's done the appraisal. There could be a number of co-defendants listed in the lawsuit. And you may not have any liability at all or limited exposure because you've crossed all your T's, dotted your I's. However, you want to have proof of all that so you can get in and out of that lawsuit as quickly as possible by showing, here's what I've done. It's all kosher. File your motion to dismiss. Motion for summary judgment means you get released from the lawsuit, okay? But even with that, you're going to be potentially filing a claim with your insurance company, out-of-pocket expenses, the stress, time, and headache of having to go through even the beginning stages of litigation. So you want to make sure that you're covered as far as your proof that you've done everything appropriately. I know there is a statute that says the agents are not necessarily liable for their seller not disclosing a defect on that standard form unless the agent has been a signatory, unless that agent signed it themselves, then they have more exposure. But if the agent has not signed it, the code says you guys aren't liable. That's great news for you all, right? You don't sign that form, you're not liable. Well, wrong, because you could be sued under another section of the code, okay? So there is an exception that kind of protects realtors. If you don't sign that disclosure, you're not liable. Well, there's exceptions to exceptions. And so there's another way to be sued. That buyer can sue you all because of the duties that you guys owe to both sides of the transaction. TCA 62-13-403 says that you as agents owe a duty to all parties, not just your clients, but to all parties. And one of the duties that you guys absolutely owe to all parties is to disclose to each party of the transaction any adverse facts of which the agent has actual knowledge of. So if you have knowledge of a defect and you didn't disclose it, just because you didn't sign that form does not relieve you of any liability. So it's critical that you guys make sure your sellers are disclosing everything that they know. And then if you know something as well, you disclose it too. Because if there's an email found in the future that shows you had knowledge of something, you're busted. You're not getting out of that lawsuit. In fact, you'll likely pay damages. So cross your T's, dot your I's, and make sure you disclose. I would rather disclose too much and cause a deal to fall through than not disclose enough and pay for it substantially later. Now, there is a 1-year statute of limitations, which means the buyer has to bring a lawsuit in regards to that claim within 1 year of the closing.
I think this also goes to if you've got a listing and you get an inspection, get information from the inspection. I don't really know, maybe Joey, you could speak to this, how it works once, if you've got the listing, then a buyer does an inspection and it's going to fall apart because of the inspection. If something of that inspection has been disclosed to the listing agent, now you have knowledge of it. Yeah. So that's definitely something to be aware of.
Yeah, and I'm going to give you 2 real-life examples of 2 lawsuits involving realtors. I won't disclose their names. It's not a local case anyways, but I'm going to keep it all confidential. This wasn't a case that I personally handled, but it was a case that went all the way up to the Court of Appeals. So the buyer of a piece of property was suing the seller, the seller's agent, and that agent's brokerage firm for failing to disclose an adverse fact. And so that realtor was sued, had to go through months and months of litigation, very expensive litigation. And thankfully, this agent was able to document the fact that she did not have knowledge of anything. She had no knowledge of this and was able to save herself. But she didn't have it well enough to show at the beginning of the case. So she had to endure a lot of litigation because of it. So her sellers didn't disclose, and she had to pay the price in the form of attorney's fees and things like that of her own defense. So just be aware, because it can happen. Another case, another agent was sued because there was a landfill behind the home of her sellers. Okay, the buyer purchased the home, and a month after the purchase closed, the landfill bought 200 acres across the street to expand its operations. So you can imagine how the buyers felt about that.
Anybody have listings in Bristol?
The buyer was livid, filed suit against the seller, the agent, and their brokerage firm, claiming that they had knowledge that this was going to expand, and they failed to disclose it. Thankfully, they could not prove that claim, that they had knowledge. It was published in the newspaper a month after their closing. That's when the agent and the seller said they found out about it. But fun fact, the brokerage manager knew about it, and he did not disclose it.
Ooh.
But in this specific case, and this may not be the case all the time, but in this specific case, the court said the brokerage firm is not liable for this because he or she, that firm, is not the agent. The brokerage firm is to oversee the agents. The agent isn't the one that actually had the knowledge, and so they weren't liable, thankfully. But that's just an example of what could happen. It could have went another way, so just be aware
certainly.
of how costly failing to disclose could be.
Yeah.
Okay. What else?
Okay.
Any questions about that? Any questions about failing to disclose any liabilities in that? I know you guys deal with that.
He was saying that if the agent even says that it's kind of like hearsay, there was flood damage or whatever, it's still the responsibility of the agent to check that out. Because is that true, you think? Like even if they don't disclose it on
Like the seller's agent? Yeah, I mean, I think there could be some liability there if they have knowledge that there could be or has been a defect. They may not have personally seen it, but if they have knowledge, I think they have to disclose there might have been flood damage.
There's more so the idea of like, hey, sometimes the basement floods just a little bit. They put like basement floods a little bit, big rains, and then they move in and it floods a whole lot. And they sue, like you said, a little bit. This is a lot.
Very good example. There are cases in which language like that, misleading or underreported language, it's like, well, I reported it. Well, you severely underreported it. Okay. So yeah, be careful with your language in those forms, because if it's something far more severe than what you identified as, they could come back and say that you knew more than you disclosed.
Typically when we give, so when I go on a listing form, whatever, I meet with them, I go over forms I need to, I leave them homework, and part of the homework is the property condition form to fill out. So I'm like, fill this out to the best of your knowledge, and I don't really want to be in the room with you as you do it. Somebody, you told them to do this or leave this out. So I leave it with them. So how does that work on that side as I walk to the home and say, think of any time for my flood damage and stuff? If I walk away, they fill it out. If I'm coming back, at what point now is it my burden to like go over that and make sure that everything was disclosed at that point? Like, better that I'm there and kind of coach them, or do I go, here you go, and walk away and let them do it?
and make sure we say that.
Okay, so Matt's question was, if he, as the seller's agent, is at the home and he's given his client the property disclosure form to complete, is it better for him to leave the room and let them complete that form by themselves so they don't feel coached, or they can't say that he coached them anyway? Or is it better for him to be in their room and give them some guidance? Is that your question? So that is a good question. I don't know if there's a clear-cut answer for that. There's arguments to be made for either way. Okay, if you're not in the room, the seller could say, well, you know what? They could turn back and say, well, I'm blaming my agent for this. And yeah, I didn't disclose it, but my agent just gave me this form and walked away. I didn't know what to do with it. I'm not an agent. I didn't know what to disclose and not to disclose. I didn't know how serious it was. I didn't know what a material defect was. I don't know what that means. Or, if you are in the room, they could come back and say, well, my agent told me to do this. My agent advised me to do this. He was sitting next to me when I wrote this down. He saw the form. We discussed it. So either scenario, there's arguments to be made. I don't know if there's a better one option or not, A or B, but just be aware that as much as you can probably get in writing saying, hey, I remember that we discussed this and this and this. As a reminder, you've disclosed this and this. There's nothing else. You may want to just follow up with writing emails. That's you probably can't do that enough. CYA emails. We all know what that means. You probably can't do that enough.
Yeah. Document, document, document. That's what I always tell my staff. If you don't document it in their file, it didn't happen. So, the best way to protect yourself is to document your file with everything.
Yeah.
Good questions.
Yeah, question. We legally have to disclose like a homicide or suicide, correct?
I'm not aware of that. I don't think that would materially affect a property value or living in a property.
The language that I read in here doesn't affect anything that could adversely affect the structural component of the home or something like that. So the kind of lighthearted thing I joke about. There's a crazy axe murder in here. You don't have to talk about it unless he missed and hit like a stun.
Okay.
Yeah.
Maybe, yeah, maybe. There's a massive blood stain that's warped the floor in the basement, and you've got a rug over it, and you knew it was there. But generally speaking, the fact that a crime like that has occurred, I'm not aware of any law that requires you to do that just with that fact alone.
One more on that. So we do have a lot, especially in this season, of heirs selling parents' homes and things like that, in which they didn't live in the house the past 3 years, so they checked that box and say, well, I don't know. But even as they've been around the house, if they've learned something, that's something they still do because they have that exemption. It's not my primary home. I don't live here. Like how, and at that point too, we don't need a property condition update because they don't know anything about the property.
And restate that.
Okay, so the question that Matt had or has is, what about the scenario in which, for example, an heir is selling the property that he or she have not lived in the last 3 years, which would make them eligible for the exemption. They don't have to provide the disclosure, but they know of a defect. Do they have to disclose it or not? The actual seller, I'm not positive. However, if you, as the agent, know about it, then if you don't, you're breaching a duty because you still have a duty. You still have a duty to all parties involved under that statute to disclose all adverse facts in which you have actual knowledge of or notice. So under 62.13.403, duties owed to all parties, it says you have to disclose any adverse facts. Okay, and that's a different chapter, I think. Yeah, that's a different code section than dealing with the actual property disclosure form. So yeah, you may avoid liability under the disclosure form section of the code, but you'd still be exposed to liability under the code section that says you have to disclose any adverse facts that you have knowledge to.
Good stuff. Okay. Any other questions? All right. So one other one I thought we could talk about is breach of contract, because I've been seeing this a lot lately where a lot of people are moving here from out of state. They're buying properties sight unseen, and they maybe did like a FaceTime walkthrough or something, showing of the house. They get here, and this has probably happened literally 4 times just in the last few months. The buyer comes into our office and says, I just did my final walkthrough. I don't like the house. I'm backing out of the contract. Well, that's not a reason to back out of a contract just because you show up and the house doesn't look like you thought it would from your FaceTime showing. So that right there is a breach of contract. So the seller then can, if they don't actually close, the seller can come back and sue them for damages for the time that they lost having it on the market. Thankfully, I think 3 out of those 4 times, the agents were able to save the deal and work it out. But there's the one time that they didn't, and now they're in litigation over it. So all that to say, if you've got buyers coming in from out of town, I would highly encourage them to take the time to make the trip here to view homes in person. And I realize that a lot of times they can't and won't, but you should disclose that to them in writing in an email and save that in your file so that if litigation ensues, you're probably going to get brought in one way or the other. You've at least got documentation that you encourage them to come in and view the home.
Yeah, I agree.
in
I
person.
think that's probably wise to at least send an email that says, "Hey, I recommend you come in and see it in person."
Yeah.
That way,
You've covered.
it tries. You're alleviated a little bit as much as you can. You'd rather, if you're going to be brought into a lawsuit, you'd better to be involved as a witness than a co-defendant.
I have a quick question on that too. So I've had some buyers and even buyers agents. One in particular struck me to where, again, I'm not an attorney, but from how I understood the contract, I thought, hey, this is going to be a lot worse than I think it was. The person said, hey, I have a finance contingency waived, showed proof of funds, I have the ability to purchase this property with all cash. Still, as a buyer, retain the right to get a loan. They did, but it said nothing on that financing side will stop you from being able to home. So when it started to shake towards the end, timelines were getting hairy, things were going out. We were on the sell side of like, hey, we'll go ahead and start proceeding as with cash now. No, we won't do that. We would only give up earnest money if it had to die. No, you would be forced to buy this home. That's because a lot of people I'm feeling, if something goes sideways, I lose my earnest money. And I think that they think that's the worst that will happen. From what I've understood in the contract, that could happen on top of litigation for non-performance.
Mm-hmm.
Not just, oh, you get my earnest money. It's, yes, you can lose earnest money, but then also you can have someone force you to purchase this home because
Yes.
you just defaulted. And
Just right.
It's definitions within the contract of what a default is.
And the seller is going to sue for specific performance of the contract. I mean,
And actual damages.
yes, yeah, and those can rack up because think how long they've had it with your buyer under contract, and it's now not been on the market. They've not been marketing it to potentially a buyer that could have brought a higher price. So, but yes, I believe that's absolutely right. That buyers think, oh, I'll just lose my earnest money, but if you back out of a contract for just anything that's not defined within the contract, then you're subjecting yourself to a lawsuit
with significant damages, more so than losing of earnest money. I don't recall what your specific contracts say, but I imagine that there is a clause in there relating to attorney's fees too. If somebody has to sue the other, there's going to be an award of attorney's fees. That in of itself could be hundreds of thousands of dollars, in addition to the other actual damages.
That was my impression because so many people say, well, I just forfeit my earnest money then. I think that, yes, that is an option. However, there's other fees as well, and it doesn't look good on you. So it's like,
Sure.
You can do anything, but it's not without consequence.
Yeah, and I would even say, like, when you are writing an offer for a client, that you and some of you may do this, go through the contract with them, maybe saying, I'm not an attorney, I'm not giving you legal advice, I just want you to see the highlights of what this contract says. Would encourage you to read it yourself, but kind of go through and like highlighting some of the big stuff, especially what does default mean. I mean, obviously you put your contingencies in there. So if there's inspection issues, and that's different. But a lot of times right now, we're just seeing so many out-of-state buyers, and they come here and they just, like one, they came in like, we don't like the driveway. I mean, there's that, and so they're walking, and that's not a reason to get out of a contract.
If there's been some type of fraudulent misrepresentation, that may be a way to get out of the contract. Even potentially negligent misrepresentation of a material fact. But because you don't like the driveway or the wallpaper, good luck. Good luck winning that one.
The reason I say to encourage your buyers in writing in an email to come in and actually see the property in person is because one of the ones that went sideways at my office, and the buyer was in and out several times throughout the day. And he said, I'm hiring an attorney to sue my agent. My agent did a FaceTime walkthrough, but she didn't show me this, or she didn't show me the wall heater or something like that. And so he ended up, he ended up buying the property and turn around and sell it again, listed it with the same agent that he spent all day.
He or she could have
arguing
been
about.
that bad then, huh?
But he was at that point. He went outside and was finding various attorneys to call to see who could meet with him that day to get out of the contract and sue his agent, his buyer's agent, for.
There's definitely something you can put like a special stipulations about that, like not like a viewing contingency, but like some sort of contingency upon them seeing the property. Is there any kind of special stipulation you can add in there?
You could. I mean,
Yeah.
if you want to add that into a contract, everyone agrees to it. You know, that
I
there's
would think
contingency
about
based on that.
that in your contract directly with the buyer.
Yeah. Okay.
Yeah. I've
Yeah.
done that a few times.
Yeah, yeah. That's
I think where people hesitate on it is if I'm a seller's agent, I would advise against it. Like if somebody said, "Hey, yeah, I want to give you over asking this, that, and the other, contingent upon me viewing the property, finding it." You get another one. It's like cash no inspection.
Oh, sure.
I'm like,
You mean like in a multiple offer
you-
situation?
yeah, 'cause that's the client.
Yeah, that's
Yeah.
why I wouldn't necessarily put that in in an offer that you're submitting to a seller, but like in your buyer's agreement, like if you, yeah, just in your buyer's agreement directly with between you and your client.
So you wouldn't like disclose that?
Disclose what?
The fact that they're like they've never seen the property?
To the seller,
Yeah. to the
I
listing
don't think you have a
Um,
duty to do that.
Okay.
No.
But if you wanted to put it in your offer, I mean, you could. I mean, they may get rejected, but
Yeah.
Most listing agents, when you start getting multiple offers, I've been getting, has your client seen this in person?
Sure.
And if I say no, it's on FaceTime.
Right. And I
Yeah.
understand that. I understand that from a
Yeah.
listing agent's point of view. Like just say us as the buyer.
Yeah.
The buyer's agent.
Well, which
Yeah.
Yeah.
in this market, yeah, you probably would be able to do it.
Right. Right. It's
4 or
just-
5 years ago, when I first started, you've seen that all the time.
Sure.
Yeah.
It's got to be approved by the buyer. When they come see it within 5 days or something.
Yeah.
But
And
now, no.
Yeah.
and it's tough to cover yourself in that situation because you do it on FaceTime where they can direct you to look at every corner, up, down, left, right, open this, close that. Or you do it by sending a video. And there's a video documented evidence of what you did, but there's also video documented evidence of what you didn't do then.
Yeah.
So, there's no perfect way to do it. That's just the reality of where you guys are today in terms of
Yeah, it's just
long
a different
distance.
market.
Yep.
And I would also follow that with, I know sometimes agents will do a final walkthrough for their client. That makes me nervous for you all because I would get some sort of disclosure signed by them, something in writing from them because they are agreeing. They're wanting you to go do the final walkthrough. I would get that agreement in writing from them, and that you have no liability if something is not up to whatever their standard is.
Yeah, and I don't even know how much of that you could really waive because you owe a duty to them. I think you can only alleviate yourself from so much liability there. So that's going to be a sticky situation if you're the one doing the walkthrough and signing off on it. I would be very nervous to do it.
Yeah.
Get here, then they have the ability to waive the final walkthrough. Do I mean, just put the burden on the seller. Hey, we'll show where the invoices or photos showing things done. If my buyer can't get here, we either need to get there beforehand or you have to wait. That mitigate risk on that side.
Well, then what if your client says, well, you told me to waive it because I couldn't be there. I told you I couldn't be there. I told you I live in California. You're my agent there. You said you could handle this for me. You said you're in Tennessee. You said you could show the property. And you told me to waive it.
I mean, honestly, I guess you could kind of take it on a case-by-case basis, filling out your client what you think is maybe a safer route. I mean, if you're dealing with a client who's super contentious and has just been difficult the whole time, I wouldn't do it.
That's true. If you have someone that's been a pain, there's a good chance that they're going to be a pain in the future. These are tough scenarios. There's going to be no 100% clear-cut way to alleviate yourself from any risk or liability. And that's like any job profession. Us as lawyers, you guys as agents, just that's why we have insurance for the unfortunate
Yeah.
event that would happen and it would get that severe. You just have to do the best you can.
I think Joey said to me one time when we were doing an event or something, he said, it's not a matter of if I'm going to be sued, it's when. So, it's if you're going to have a lengthy career in this, it's probably going to come to you at some point or the other, but that's why you have, insurance too.
And you just do what you can beforehand to try to lessen the likelihood of that happening.
Lessen the likelihood, and if it does happen, to better your chances of getting out of it.
Yeah,
altogether.
as quickly as possible.
Yeah. So document.
And on the document part, text messages, they count those now.
That's evidence that can be admissible as long as you can authenticate them and say, this is my text, I sent it, this is what they said, this is the number I sent. Yes, if you can authenticate that, then that's admissible evidence. Emails, text, phone calls in Tennessee. You can record the phone call in Tennessee that you're having with somebody without their knowledge if you want to. It's legal to do that in the state of Tennessee. It's a one-party consent state. So if you have a call with somebody and you want to record it without their knowledge, you're allowed to do so. It is illegal to record the conversation that somebody else is having that you're not part of in Tennessee. Okay.
Yeah. So if you have some of those difficult clients, I would recommend getting one of the apps to record those phone calls if you have to take phone calls.
Absolutely. If you have a difficult client, one that is always threatening to sue everybody, trying to place blame on others to protect yourselves, I would leave it all in writing, or anything that's done orally on the phone. Record that call to protect yourself. Put it in a Dropbox and save it. Okay. Another issue aside from breach of contract, just real quick issue, practicing, let's see, what was it?
Giving legal advice.
Yes, giving legal advice. So in the state of Tennessee, giving legal advice, or also known as unauthorized practice of law without a license, is a Class A misdemeanor. That's 11 months and 29 days in jail, okay? Or fine. Up to that amount, that is. So avoid giving legal advice. Don't advise someone of this is what the law is and this is how it's going to be interpreted. You can generally tell people, what's in their contract, and you can go over that with them, but don't start telling them, when they can't sue or be sued, because that could be considered giving legal advice. It's a fine line, especially for you guys.
It is a fine line, because I think too, like you were saying, Matt, telling your client, and this is the same case I was talking about in my office, the realtor's on speakerphone saying, if you don't close this today, you're going to get sued. That was, I don't know, what's the best way to...
The way to phrase that is, if you don't close this, you might get sued.
Yeah.
You may be sued. You should consult with an attorney.
Yeah.
That is the best way to phrase that. Tax advice. Careful on giving tax advice. Yes. Be very cautious on that. Me, as even lawyers, have liability of tax advice. Unless you're a tax attorney or a tax professional, we have limitations on giving
I can't give any
advice.
I get lots of questions, of course, at closing about tax stuff. And I have to say, I'm not a tax attorney or a CPA. I can't answer that question. So, if you're getting a question that's like, just say, I'm not an attorney and I can't give you the answer to that. I would recommend contacting an attorney to discuss. Because that's another way to get sued.
Yeah.
By your client.
In recap, so far, failure to disclose, breach of contract, giving legal advice. It's 3 ways to potentially land yourself in court. Okay. Any other hot topics that may land agents in hot water in lawsuits?
Those are the 3 main ones that I've seen just in my own practice happening in my office. Are there things that you guys are seeing out there in some of the situations you're dealing with? I know, Mackenzie, we were talking earlier about one of yours. But is there anything that you guys have come across that you've seen and you're like, oh, I don't really know how this might turn out?
Something that I've seen that I think a lot of agents are just skating around on and just not getting busted for it is false advertising. I think particularly as bedrooms. Say, oh, it's a 4-bedroom home, and then as soon as we get under contract, it's a septic tank. Pull the permit, it's perfect for a 2-bedroom, 4-bedroom home. False advertising. It's not actually a 4-bedroom home by law's standpoint. So we see these all the time, and the same folks doing it. So I can't imagine that that's something where it's like, oh, you guys, you didn't know. You saw 2 ways in, 2 ways out, you're fine. I imagine it's like, no, like you should have pulled the permit. You have a professional duty to protect your client here, and you didn't do that. So somebody came back.
So Matt was saying, for those that's online, Matt was saying that he has incurred more real life examples of agents listing or doing false advertising, but more specifically listing a 3-bedroom unit as a 4-bedroom unit, knowing that it's not 4-bedroom. That's problematic because I think that, circle back, I think that's a violation of 62-13-403, just duties owed to all parties.
Is that where you said they purposefully detailed it as a 4-bedroom, knowing that it wasn't? What if they?
Yeah. So I think if they fail to disclose to each party the transaction any adverse fact that the agent has actual notice or knowledge of, that's a breach of duty. So if they know, if the agent knows this is only a
They don't know that negligence helped them in that. They're just like, oh, I just didn't know.
I mean, that could be a defense. Would it be a winnable defense? I don't know. That could be viewed as a negligent misrepresentation. It doesn't have to be intentional. There's intentional misrepresentation, which is the more serious one, but there's also negligent misrepresentation.
I think too, like, the court may look at that. What is, as a real estate professional, what is done in the ordinary practice of your business? Pulling permits when you list a house, is that an ordinary part of your practice? Then yes.
People have gotten to the point of getting by without doing things like that.
Yeah.
Nobody really, and I'm guilty of some of that too, but I feel like there's, at times,
Hypothetically speaking, you are.
I'm sure that I have been some, but you know what I mean? I feel like it's, that's why I think like here, like we try to keep this up to date, rules like that. But I feel like there is just go out and do it type attitude.
Mm-hmm.
It's not educated on what needs to be done. That I feel like.
I think you're right. Sometimes it does come down to it's not intentional, simply because you weren't educated properly, and so it could be considered negligent if that's the ordinary standard and you failed to adhere to it.
Oh, I got insurance coverage for that. Yeah, but it still isn't fun.
Yeah,
Right.
that's still going to take up a lot of your time where you could be out showing houses or, having closings.
There is a form to pull the permit for us to send to the state to pull the permit. We require everybody to do it.
That's good.
Good idea.
Because
That's
we
good.
heard at, actually a appraiser told me at Matt at Harris house, he come to look at it one time and told us that a listing agent didn't pull the permit, sold it as a 5-bedroom, because it had 3 upstairs, 2 in the basement. When the permit come back, it was a 3-bedroom when the new owners went to sell. So they sued the agent. Got like $25,000 per bedroom or something.
Well, see, there's a good example.
$10,000.
It's a good example right there.
So
Yeah.
we require him to pull it because we don't want that to pop up on us. Once we learned that, and we were still at the other brokerage, we were like, yeah, we're going to pull this permit.
Yeah.
It's a hassle, but
It's common in this area because you have these old farmhouses that are originally 2-bed, 1-bath, and then grandpa saves up, and then he decides he's going to add on a bathroom, or he's going to add on a bedroom, or they're going to do whatever, and they make it a bit more modern, but they don't go dig up the septic
a lot of times you can't find them, especially like Johnson County. They had a fire back in the 90s and it burned up most
Yes.
of the records.
Mm-hmm.
So we get that back a lot. That at least we did try,
Right.
and couldn't find any files. So I tell everybody, just if it comes back to files found, at least we've done our due diligence to try to get it. Because some of them don't, like Matt said, those older ones. Some of them I don't even think had permits back then. They just started putting stuff in without even permits in these smaller counties, and you can't find anything.
I think it's good policy.
Yeah,
I think
I
that's
think
very
so
good.
too.
Because I know if they go to court, I'm going to court, and I don't
Yeah.
go to court.
Yep.
Yeah,
Because-
Joey, you're involved whether you want to be or not.
Yeah.
Because these people that are suing, they're going to sue multiple defendants for a greater likelihood of a payout. All right, well, I'm going to sue the agent, but I'm going to sue the brokerage firm because that's who maybe has a deep pocket with a better insurance policy. So I'm going to sue them all. I'm going to sue that, A, B, and C to see who I can squeeze out of. Who's going to pay me money just to settle this case and get out of it, right?
Mm-hmm.
So it's good to have those types of things in place to get you in and out of a potential lawsuit quicker.
Another question. Had it happen to me, luckily, said, you checked the right boxes on that, being a facilitator. I had a seller that wanted to sell his property, and all he told me at this tree, he said, when it rains, it puddles right here. I'm like, okay, so what? Puddles right there. So when they bought it, the buyer, I had both sides, but I became a facilitator. So I didn't represent neither party. I didn't advise neither one. When it closed, it was probably 2 weeks into it, the bathroom backed up into the house. They called septic people, and they're like, oh, we've been out here 3 times and told them to do these fill lines. Well, I'm at home one Sunday sitting there, and the guy goes, I'm suing you and everybody that was involved. And I was like, I didn't do anything, but I was a facilitator. So I called Jess. I was like, I was a facilitator on this, blah, blah, blah. And she's like, you checked the right thing. You did the right thing. Because I didn't have any knowledge of it. But to save, like, the whole deal and everything, like, nobody getting sued, I paid to have it fixed. It was like $2,500.
Wow.
And I did it to cover, just in case, And I had an old broker told me, he said, just file it on your E&O. Don't worry about it. Just follow me. Yeah, it's nothing. I was like, dude, I'm not doing that because to me it probably would run our E&O insurance up.
Yeah.
Then it's going to make it more. We'd be more of a risk for the company, and everything. But I did learn a lesson on that, to make sure if I'm doing that to pull myself into a facilitator. I tell everybody here, do not try to represent neither one, or do not represent one and put non-represented. It's easier if you're the facilitator. It takes less liability off of us, and
Yeah, I think you're totally right about that. Definitely,
Yeah.
definitely good tip.
Forms they just added unrepresented, represented.
yeah,
So it's better.
just be a facilitator, not
Yeah.
represent nobody.
Jeff, can you kind of walk someone say it?
Yeah, so in Joey's scenario, he didn't represent buyer or seller. He had on his form checked the box that he was a facilitator. So he wasn't the agent for either party, and therefore the duties owed to the parties are different. So he had no knowledge of there was a septic tank issue. So that when the buyer called and said, I'm going to sue you over it, well, Joey could say, no, here's the form you signed where I'm just the facilitator. So
Limited duties.
his
there.
limited duties to either party. I would say, I don't know what you think about this, maybe you'd be careful about if something like that happens again, that you offered to pay for it to keep the deal together. If it messes up again and they decide they are going to sue, could that be seen as an admission of guilt by trying to fix it?
Get a
What do you
good
think?
settlement waiver signed. That'd
Yeah.
be good.
Yeah.
That'd be good saying that they are waiving any and all causes of action, known or unknown, against you in exchange for this. No admission of guilt either should be in there.
Yeah.
Things like that would be helpful. Keep in mind when you're being the facilitator too, as to not cross the line accidentally. You don't accidentally get more into the role of representing the buyer on an issue or representing the seller. Make sure you stay in your lane.
Yeah.
Because even though that box is checked, if your own actions, and there's proof of it, lead one to believe that you're their agent, then that checked box may not be sufficient if there's proof to back up. Well, yeah, we checked the box, but here's what the actual actions are that are documented. So be careful when you're doing that to stay in your lane as to not accidentally breach a duty that you didn't think existed at the time.
And in Virginia, we don't have that. You don't have you represent them, you're unrepresented, you're a facilitator. When you sign a buyer's agreement or the listing agreement, but to be a facilitator, we have to put it on an addendum.
Oh,
So that's how I did. I wrote it up as an addendum. You know, that both parties agreed that I would be moving down to a facilitator because their forms are, I don't know, they need to be more like Tennessee. Have different boxes like that
mhm.
to where you can put yourself in what position in the transaction, the facilitator or the buyer's agent or something. So in that, we have to do that in Virginia. You have to write an addendum. I think they're still
Gotcha.
stuck in 1960.
Yeah, those contracts.
Yeah.
Antiquated Virginia.
They kill me.
And they don't have, on the contract, they don't have a thing if you want to accept it, reject it, or counter. If you do an accepted offer, most people think you can just do the counter, but you don't have a contract.
Right.
You just have a signed counter.
Mm-hmm.
It's not acknowledging this contract. So I always tell my agents to put in the special, it's not even special slips, it's just a blank area there, it says other or something, to put see attached addendum or attached counter. See attached counter. So I make them sign the purchase and sale agreement, then sign the counter. So it's binding.
One more thing I would touch on just about your contracts is that, and I see this a lot, and Joey, you and I have talked about this before. If your contract is expired, it's expired. You cannot counter a dead contract. Like, you just can't do it. So,
What about folks that try to go in there and do an amendment? All parties recognize this is still valid. Did I still put like a heartbeat on a dead guy? Like, how is that?
There's an exception to one. Virginia. If it expires, I asked the Virginia Association of Realtors hotline. I said, is this, because an agent argued with me. I said, this thing's dead. And they're like, no, it's not. Yeah, it is. We didn't close. You know, closing didn't get extended.
mm-hmm.
And I said, we need an extension. No, we don't. So I asked them, and they said, it could go up to 6 months. You could legally let it go 6 months and not even have to sign anything. But they, per their advice, they should be an agreement signed. But if you don't have one, it can still go for 6 months.
Interesting.
So you could think you were out of the contract because you didn't close in time, but you're still bonded in that contract. Now I'm sitting there going, how is this even legal to me? In my head, I'm like, Tennessee, no. If it doesn't close on that closing date and you don't have an extension, it's dead.
It's very clear in the contract too.
With offers as well. When someone puts an offer, there's a deadline, and then they come back the next day. Accept it.
Yeah, I
They
don't.
have a timestamp signature that's after the expiration date.
I don't know if that's a valid acceptance.
Yeah.
The Tennessee hotline, they said you cannot. Most people want to bring an amendment to the contract, and they said you cannot amend a dead contract.
Right.
You cannot bring it back
Right.
to
There's
life.
nothing.
Yeah,
to
you can't.
amend.
There's nothing to amend. And
That is not a clean way to do that.
yeah.
We've argued this with other agents and argued it, and they say we're wrong, and I'm going, look it up. There's question.
Well, read the contract.
The hotline. Yeah.
So I had an agent call the other day, and she had a pretty significant property under contract, and the wording that they used was about extending. It was a closing date. The seller could stay in the property for like another week past closing. Then they weren't going to meet the closing date, and so she was hoping somehow that language was going to save it, but it never got amended to do like a closing date amendment within the time period of the contract. It was still, so the contract's still dead. That language, and I can't remember exactly what it was, but it was a little iffy, but it didn't extend the contract. There was no amendment signed. Thankfully, the sellers were nice people. Everybody worked it out. But the amendment they signed was signed after the contract was expired, so it was no good. So be careful about that.
Mm-hmm.
I see that a lot, and it's a big one. Also, making sure you have fully executed contracts. A lot of times we get contracts sent to us that don't have buyers and sellers' signatures on them, maybe one party and not the other. So, and we always are requesting, gotta send fully executed contracts. So just make sure you've got that documented.
I know back a few years order of who bound what, but like if I get an offer and my seller signs it, can I bind it at that point, send it back to them, sit down contract, or does it always need to be the person? They send an offer, we sign it, and if they bind it.
Wait, what's that question again?
So on binding a contract, it's like we send an offer to a seller, they accept it, they send it back to us, it says accepted and it's signed. There's a place at the bottom of the contract that goes, all your time frames and all that stuff starts once you bind it. At the bottom, the agent signs it. Yep, we have received an executed contract. At that point, that's when the clock starts. Can anyone do that, or is there an order of, well, if you sent it and they signed? I know that's how it used to be. Does that make sense?
I think it's like, if you send me a contract and I sign it, my seller sign it, and I send it back, I'm supposed to send it back to you so you can say that you have received it.
Mm-hmm.
Because if I bind it, I can say, okay, my seller signed, we're good to go, it's bound. Because a lot of people do that, a lot of listing agents will do that, because that's when you're, like Matt was saying, that's when the clock starts at your inspections and everything. So if I know you're going to be a little shady and like not bind it till tomorrow or something to get an extra day, a lot of listing agents will sign it now. So they block you from, then your time starts actually the next day anyway.
Gotcha. So I think there's an argument if there's an offer and it's accepted, but there's a missing signature on what defines the binding date in the timelines. I think there's a contract formed at that point. I think there is vague terms now in that contract, though. But the court may say it differently
It's always up to the court, huh?
if it gets that far.
That's what I was thinking. I was like, we could sit here and say, well, we did this or we did that, but it's really what their interpretation is.
And there's arguments to be made both ways sometimes, both valid arguments to be made.
I'm glad I'm not a law. But yeah, real estate is bad enough.
It sounds like a good summary is disclose document.
Disclose document. Disclose
Even
document.
in the sense
Yes.
of, as I was thinking, I have my little funny jingles that I'll say as I go through house. I'm not a home inspector, don't sue me. I'm not an attorney, don't sue me. I'm not this, don't sue me. But then again, it's Johnny Depp trial. It's all hearsay. You know what I mean?
That's all hearsay.
So at the end, am I able to then at that point, hey, I appreciate it right here again, looking at that foundation. I'm not a home inspector, so I would recommend send it like after a showing type thing. So at the end of everything, you're kind of just like
Sure.
some sort of written documentation of, hey, I reviewed our conversation for the showing, and reinforce it.
Sure. And you guys already have, it seems like a lot of good forms and disclosures at your disposal that help with that type of stuff. But I don't think it would hurt to even send further acknowledgments.
Cool.
All right.
Good questions.
Well, thank you all for having us.
Yeah, thank you guys.
Thank you.
Appreciate being with you all, as always.